recognition of foreign decrees. What do we mean by recognition of foreign decrees? I think I've explained that to you before. Somebody goes to Ghana and dissolves his marriage with his wife with the intention that he should be able to marry another lady in the Ikoyi marriage registry. He will discover that he has undone himself if Nigerian law does not accept that decree, that divorce decree he had obtained in Ghana, because Nigeria will continue to treat him as if he remained or remains married. And especially if he's, if she is the woman, okay, she will not be able to marry under any other law in Nigeria. So our attempt to marry monogamously in Ikoyi registry will be faulted. Caveat will be lodged, and the marriage will not go on. So it is very important that people should obtain decrees that will be recognized in places where they want to act upon it. Now, you know the thing with recognition that we told you. We said that you need mere recognition if judgment is status judgment. A nullity or default decree is a status judgment. So it doesn't need enforcement unless it's accompanied with an order to pay money. Okay? Maybe alimony or what have you. Or there is matrimonial property and orders are made, or orders is made regarding maintenance, which will involve a regular payment of money. In all of this, a decree might be accompanied with a need to enforce monetary judgment. Otherwise, all that a decree needs is for it to be recognized in the place where the beneficiary of the decree wants to enter into another relationship. So every country must also have our own rules for recognition of foreign nullity and divorce decree. Okay? There is what we call committee. The principle of committee requires that the rules for recognition of foreign decrees should be as liberal as possible. Why? In order to avoid a situation where you have limping marriages. Limping marriages. How can a marriage limp? How can a marriage limp? A marriage can limp if a spouse, as he moves across the globe, will be recognized as being married in one country, but has not been married in another country. The marriage is limping. Eh? You know how you play, is it 10-10 or which one you play when you were children? When you will draw squares and you are supposed to jump one particular square and land on another. That's how that marriage is. So the spouse will go to Ghana. Ghana will recognize the divorce decree he obtained in Nigeria. So he will be able to land there. But he may not be able to land to the next country, which is Cote d'Ivoire, because Cote d'Ivoire does not recognize that marriage. So that marriage will be a limping one. Eh? It is recognized in one country, it is not recognized in another. The same thing with effect of divorce. If a country does not recognize a divorce, then it will deem that the parties are still married. Okay? So in countries where the divorce is not recognized, the spouse is treated as still being married under the marriage that was dissolved or nullified. And he gets to another country, because that country recognizes the divorce, he is deemed to have a status, a brand new status that will permit him to marry in that country. So by policy, countries should have very liberal rules of recognizing foreign nullity and divorce decree. Okay? And most common law countries are fully compliant with that policy, Nigeria inclusive. So what we'll be discussing, you will find in your Matrimonial Causes Act, you will read your sections 81 of the Matrimonial Causes Act. Okay? Professor Agbede's long book also discusses it. But if you have with you a basic text on conflict of laws, you can read those texts, because our rules are not different from those of England. So what are the bases for recognizing foreign divorce and nullity decree? Rule number 1, when I give you my slides, I think this one is slide 13, straightforward. Rule number 1, generally, decrees obtained by a spouse at the country where he or she is domiciled will be recognized in Nigeria. You know, we told you that the basis of divorce decrees, the basis of jurisdiction for any matrimonial causes is usually domicile. So it is the people who are domiciled in Nigeria that we will allow to utilize our court, either to dissolve their marriage or to nullify it. So since we ourselves use domicile, naturally, if somebody has dissolved a marriage or gotten the marriage nullified in the place where he or she is domiciled, it will be unfair of us to say, sorry, why didn't you come to our country? What's our own there? We are not interested. He has gone to the place where he's domiciled. We ourselves said, unless he's domiciled here, we won't allow him. So there was no way he was going to come here, because he has gone to where he was domiciled. And because the marriage had been dissolved at the place where he's domiciled, we are going to accept it. Authority, Lemestria and Lemestria. But it is also found in section 81. Now, I don't know the subsection. You take the Matrimonial Causes Act and look at what subsection of section 81 establishes that. Those of you who have done family law, maybe you have treated it more closely. Okay, but the English authority that Nigeria followed in codifying that principle is the case of Lemestria and Lemestria. You can take your time to read Lemestria and Lemestria, what happened. Okay? 2, some countries permit residence as a basis for jurisdiction in matrimonial causes. Even we too, we permit residence in a limited way. Remember, I told you that we have what we call special domicile for married women to protect them from having to pursue their husband across the globe in order to dissolve their marriage. And we said we give them special domicile if they were resident in Nigeria before the marriage, if they were resident in Nigeria immediately preceding the husband abandoning them, and 3, if they have been resident in Nigeria for the last 3 years. Okay? So we, in a way, too, would permit a woman who is resident in Nigeria to petition for dissolution or nullity of her marriage. So for that reason, we will also accept a decree of divorce or nullity obtained on the basis of residence in a country that accepts residence as a basis of jurisdiction. Okay? 3, Nigeria will recognize decrees obtained in another country based on the exercise of like jurisdiction of our Matrimonial Causes Act. So all those 3 conditions, all those 3 conditions, all those 3 permission of special domicile, if another country accepts them and a decree had consequently been obtained in that country on the basis of any of the 3, then we will recognize that decree. 4, we have said that we will recognize decrees obtained from the country of domicile. Suppose the decree is obtained elsewhere, but the country of domicile of the spouse will recognize that decree. Then we can't cry more than the bereaved, because our position in this matter is that the spouse was carrying with him or her the law of his country of domicile. So if his country of domicile will accept that decree, why are we going to cry more than the believers? Say, no, we don't accept that decree because you didn't obtain it in the country of domicile, in the country of your domicile. But the man is telling you that even the country of my domicile will accept this decree. So we too will accept the decree because we don't want to cry more than the bereaved. Authority, apart from the relevant subsection in our Matrimonial Causes Act, you can cite the case of Armitage and Attorney General. Armitage and Attorney General. Then Papam Barrier, the one that runs it off, is omnibus grant. Professor Agbede called it for me when he was teaching me, omnibus grant. Any other grant for recognition known to private international law. Any other grant for recognition known to private international law. The textbooks and the expert will tell you that what our legislature was trying to legislate was the principle in the case of indica and indica. Indica and indica. That is the case where the English court so liberalized the grounds of recognition by saying any real and substantial connection between the couple or either of them with the country where the decree is obtained. So, in other words, residence in you, habitual residence in you, domicile in you, nationality in you, some connection, any form of connection, provided that the decree was not a nullity or obtained by fraud in the place where it was obtained, and the person armed with the decree to continue his or her life in our country is at least able to establish any substantial or real connection. The country was his or her place of residence. The country was his or her nationality. The country was his or her place of carrying on business. The country was his or her place of habitual residence. The country was his or her domicile. Just any semblance of connection. According to Indica and Indica, we do. And the textbooks will illustrate this to you that the answer is very simple. That we, at common law, we don't accept nationality as a basis. We have already said that if the domicile of the spouse accepts it, that is all right. But Indica and Indica is dragging us forward. That even if the domicile does not accept it, if that country where the decree was obtained entertain jurisdiction because this person is our national. Okay? Suppose a Ghanaian, no, suppose a Benin Republic national, domicile in Nigeria, has obtained a decree of nullity in Benin Republic by our test. By our test, ordinarily, minus Indica and Indica and this last paragraph, we may not recognize that decree. We may say that, look, you are domiciled in Nigeria. Why did you go to Benin Republic to obtain the decree? If you say, but I'm a national of Benin Republic, we may say, well, your domicile has to accept, and Nigeria law does not accept that decree. That may be the end of the matter. But when we now get to this last count, and the Indica and Indica authority, that is any real and substantial connection, we will now be forced to accept the decree because, of course, there's a connection between this person and Benin Republic. He or she is a national of Benin Republic, and Benin Republic uses nationality as a basis for jurisdiction. So on that basis, Indica and Indica will be our own ground for accepting the decree. And that is expressly stated in the phrase, any other ground for recognition known to private international law. That's the meaning of that phrase. That is what that phrase means. Okay? So next.
Sir, good morning, sir.
Yes? Yes,
Good
what
morning,
is the problem?
sir. Please, I'm sorry for taking you back, but please, do you mind repeating Rule 3? And can you spell the omnibus grant? And thirdly, please, can you go over this analysis that you just gave, like this example? I did not get you, sir.
And I remember anything I've just said. I'm rushing to just end this class, You this girl. Okay.
I'm sorry, sir.
I think what I will just
Thanks.
do, I will round up everything I've said in 5 minutes so that I can move forward. Is that all right?
Yes, it is, sir. Thank you, sir.
I begin from the beginning in 5 minutes. In 5 minutes. I told you that based on the principle of committee, it is highly recommended that countries should have very liberal rules for recognizing foreign divorce decrees. Okay? The reason is that you don't do so, people will be having limping marriages. And limping marriages are not good for the spouses involved because their status will then remain that they were married under the marriage that was dissolved or nullified in one country, and then in another, their status will be that they are now free to remarry. So as they move from country to country, the status will keep changing. Married in country, considered married in country A, considered free to remarry in country B, considered married in country C, considered free to remarry in country D. That's what we mean by limping marriages. So in order not to have limping marriages, countries should have very liberal grounds for recognition of a foreign divorce decree. Common law countries would always do so. Nigeria is a common law country. This matter is regulated by statute, but you will find that what the statute has just done is to enact or codify the common law, very liberal basis of recognition in this country. So I start with the first ground. Somebody obtains a divorce decree in the country of his or her domicile. What do? We will have to accept it. Reason, that is our own basis too. We say that you want to seek assistance of our court, you must show that you are domiciled here. So the man is not domiciled here. He has gone to the country where he's domiciled to obtain a divorce decree. Why will we deny him the status of somebody who has become single again? That's number one. Then number two, we said there are some countries whose requirement for allowing you to file divorce or nullity decree is that you are resident in their country. That's all they want. Example of one country that does that today, England. Today in England, you will not be required to show that you are domiciled in England before you can file a decree to dissolve your marriage with your husband. Okay? So, if a country
Please, sir, we can't hear you again. Sorry, sir, we can't hear you. Justin.
Yeah, I think he's not on the call anymore.
He's still on the call. His video is running. Sir,
Sorry, I'm trying to every with this might not have interest, no? Level. You say you are not hearing me. Are you hearing me
We
now?
can hear you now,
yes,
sir.
sir.
Yes, sir.
Okay, so I was on the third one, special domicile one. I said under our own matrimonial causes act, we give married women special domicile in 3 circumstances when their husband would have deserted them so that they will lose domicile of Nigeria. 1, if they were domiciled in Nigeria before their marriage. 2, if they were resident in Nigeria before the husband deserted them. 3, if they have lived in Nigeria for 3 years. So, since we ourselves will allow a woman in those 3 circumstances to file petition here, if she had filed petition in another country on the basis of any of those 3 circumstances, we will recognize the decree. Is it clear? Questioner, is it clear?
Yes, sir. Thank you, sir.
Then the next one. Decree obtained elsewhere other than country of domicile is recognized in Nigeria if country of couple or petitioning spouse, as the case may be, recognizes them. This is the one I say we don't want to cry more than the bereaved. We have said that domicile is our recognized basis. The person is not domiciled here. The person has not obtained decree in the place where he is domiciled. He has obtained decree elsewhere. But the place where the person is domiciled recognizes that decree. Why should we not recognize it? Okay? It will amount to crime more than the bereaved because we have accorded that right to the petitioner's place of domicile. And so, if the place of domicile will not say that, why should you go and obtain this decree elsewhere? Why should we be the one saying that? So that is the one that I said the case of Armitage and Attorney General recognized. It will do you well if you read these cases to understand what the legislature was trying to enact. Then the final one, the one I call the Papambari of the whole thing, is the one that opened the gates for all manners of excuse. In our statute, we say any other grant for recognition known to private international law, any other grant for recognition known to private international law. But the experts in the subject area, they say what we are just trying to codify is the principle of the case of indica and indica. It was in indica and indica that the English court said any real and substantial connection between the couple or either of them with the country where the decree is obtained is sufficient. So I was giving you people example of this. I said, suppose a person domiciled in Nigeria, but a national of Benin Republic, had gone to Benin Republic to obtain a decree and requires the decree to be recognized in Nigeria. By our rule, he had not obtained the decree in the place where he's domiciled. So it doesn't meet Lemesria and Lemesria. Okay? It doesn't meet Lemesria and Lemesria. He is not resident in the Republic because for him to be regarded as domiciled in Nigeria, he is deemed resident in Nigeria. Okay? His case doesn't come under the special domicile instance. Okay? His case doesn't come under that. And as his place of domicile, we will not accept a decree obtained from a country of nationality. So we would have said on that basis that that is Beninese decree will not be recognized. But if you now look at the fifth ground, any other ground, and Ndidika, this one is saying if he has any real or substantial connection with the country where I obtained the decree. So we have removed the aspect of his domicile recognizing it. We will still accept it. So in this example, the man is domiciled in Benin Republic, is a national of Benin Republic. That is a real and substantial connection. And on that basis, we will accept it. Okay? On that basis, we will accept it. So that is the fifth ground. Okay? Is it clear? Questioner?
It's very clear now, sir. Thank you very much, sir.
So
Sorry,
we
sir.
have been discussing grounds for recognition. What are the grounds for non-recognition? You go to subsection 7 of section 81. It lists some 3 grounds. 1, if there was denial of natural justice. The English case, Joyce and Joyce, will illustrate that. 2, if it was obtained by fraud. There's a lot of fraud going on in issue of decrees these days. Okay? When you become lawyers, you see people who did arranged marriage in order to either to get visa or whatever, or to present themselves as married and all of that. And somehow they have a marriage certificate, and they tell you to go and dissolve it. And you go to Idumata or Kenya and get something and do it. Or maybe it was a genuine marriage. It was a genuine marriage. The other spouse, nobody knows where he is. Somebody will pretend as if it's the other spouse. We say, I'm not objecting. And a decree of either nullity or dissolution will be obtained. That is fraudulent. And if it is proven, it will make us not to recognize the decree. Then public policy. You have always known that public policy is a grant for excluding otherwise applicable foreign law. And foreign law includes foreign judgments. So, next, what is the meaning of foreign decree? You know, here in Nigeria, we only understand divorce decree to mean the one pronounced by the courts. Okay? But in many other countries, there are other ways of dissolving marriage than going to court. There are other ways of dissolving marriage under personal systems of law than going to court. I taught you one the other time, the Jewish get. Okay? There is the Islamic talaq. There are some countries that have construed the prophetic tradition and the Quranic provision on talaq to mean that If the husband pronounces talak 3 times, the marriage is dissolved. That is not actually the meaning of those provisions. We know that what the Quranic provision entails is that the couple are given 3 opportunities. And the 3rd opportunity, the wife must go and try somewhere else. Let them try somewhere else and see whether they can still live with themselves before they can remarry. That's the meaning. It is not talak, talak, talak. But there are some countries who accept that view. So if talak, talak, talak was pronounced in a country that accepts that pronouncing of 3 talaks is enough to dissolve Islamic marriage, so be it. Okay? Some countries too can dissolve marriage by what looks like legislation. Okay? So foreign decree is not limited to court order. You should know that. We can test you. We can give you problem questions. I've given problem questions on this area before. Okay? So I think on that note, I have finished with recognition of foreign nullity and divorce decrees. And I can wish you the best of luck. I'm doing something now. When I finish it, I'm going to compose a number of essay questions on conflict of thought laws. I'm going to give it to class captain and Mrs. Adeyemi. She's going to divide you people into groups and take all your time. Take like 1-2 weeks. When is your own time to write the exam?
March 27.
You have all the time this one. Take all your time. Take 2 weeks. Take 2
Sir,
weeks.
please, it's not March 7, so
Hello?
it's not March 27, sir. It's March 17.
It doesn't matter. Take what is today?
Today is 13, sir.
Take 2 weeks. The test will carry a whooping 30 marks. This
Thank you,
one
sir.
assignment will carry a whooping 30 marks. And we may or we may not present it. If I look at how you have done the test and I see that you didn't attend to it very well, I know what to do. I would examine that question in the exam so that you will regret not concentrating. But if you do it very well and I see that, I can still examine it by telling you to discuss, to present to me what your group said, so that everybody who is a member of a particular group will do well to participate. And even if you don't participate, at least read what your mates have said. Do you understand? So,
Sir.
on that note, let us take it that tentatively we have ended the class. Be ready for me to call you back anyway if I change my mind. Thank you very much.
Sir, before you go,
Yes.
sir, is it possible to get your material on marriage?
Yes, I promise you now.
Okay.
It's a material. It's just look, I'm very, very lazy in writing. Do you understand? I'm a
No.
very lazy person in writing. All of these things, if I put them to paper, you know how much you people will buy them. But what I have here is slides that I started using during COVID-19 for this particular topic. So what I would do is I will send it to Adelemi Chukwu, your class captain. Send it to him together with the thought assignments. Is that all right?
All right, sir. Thank you, sir.
He will share it with you people.
Please, sir, do you have something on sources of law? Mrs. Adoremi mentioned something a while ago that there's a particular way we group sources of law for conflict of law, and that she was going to give us something for it. But I don't know if you have something to give us on that.
Well, I normally discuss it in class. Do you understand? I normally discuss it in class, and I'm sure Mrs. Adeyemi discussed it very well with you. Do you understand? I've not written anything on it. You want to encourage me to sit down now? If you know the number of things on my hand to write, you pity me.
Yes, sir. Thank you.
Best of luck.
Thank you, sir.
Okay.